So we're going to go ahead and get started. Hello, everyone. I am Femi Cadmus. I'm the director of the Goodson Law Library. I've been director for just about 2 months now, so I'm a real newbie. I'm pleased to welcome you to our faculty author celebration for the new book by Professors Joseph Blocher and Darrell Miller, The Positive Second Amendment, Rights, Regulation, and the Future of Heller. Now, you can find a copy of their book in our library. We have a couple of copies. You can actually find it in almost 100 libraries around the world. And last time I looked, you could find it in the National Library of Scotland, the Max Planck Institute Library, and the International Islamic University of Malaysia. So it's all over the world. Now, if for any reason you can't find it in the library, you can get it on Amazon. And you can get it in the Kindle version also. So buy it. Give a good review of this book because it's a great book. Now, since 2015, the Law Library and the Office of Dean have co-sponsored the Faculty Author Celebration Series, and we've done many of them. And we want to do this to celebrate and recognize selected faculty book publications throughout the academic year. And I just want to say thank you to those who've helped make this possible. Of course, our co-sponsors, the Dean's Office, our Library Business Manager, Sue Hicks, Jennifer Behrens, who's our Head of Reference, and Media Services, who are making sure that everything goes without a hitch today. So thank you all for being here. Now, today we're going to have, leading the conversation with Professors Blocher and Miller, our Senior Associate Dean for Faculty and Research, Dean Maggie Lemos. So please join me in welcoming Dean Lemos right now as she introduces Professors Blocher and Miller.
Hi, everyone. Thanks for coming here today. We're very lucky to have Professors Miller and Blocher here to talk with us about their new book. Both of them have written a great deal about the Second Amendment before coming together to write this book, and surely will continue doing that. And so I think that unequivocally makes Duke like the world capital in expertise on gun rights and regulation, which is cool for us. So today we're going to focus on the book, but I think also probably talk more broadly about debates over gun rights and regulation today and what the Second Amendment has to say about it. So the book starts by tracing the history of gun regulation and gun rights in the US. Actually, it starts in England and then moves to the US colonies, through the founding, out into the Wild West, through the Civil War, the New Deal, the Civil Rights era, all the way up to today. And it shows that we've always had gun regulation in the US, but also in a meaningful sense have always had gun rights, even before 2008, when the Supreme Court held in Heller for the first time that the Second Amendment right to keep and bear arms protects purely private purposes like self-defense and creates an enforceable individual right. And so the bulk of the book is devoted to taking that individual right seriously as law, as positive constitutional law, and working through what that means for gun regulation and gun rights today. Now, when I put it that way, it sounds kind of obvious and certainly not provocative at all for two law professors to look at a provision of the Constitution and say, hey, that looks like law. Let's think about it like lawyers. But I understand that in the context of gun debates today, it is actually a non-obvious and important and even kind of controversial move. Because in those debates, the Constitution tends to be thrown around a lot. Well, not so the Constitution does not tend to be thrown around a lot, but references to the Constitution and to the Second Amendment tend to be thrown around a lot in kind of a slogan-y way, as opposed to as real legal argument. And so trying to take this seriously as law and make legal arguments about it is, as I understand it, a move in this field. But Joseph and Darrell will be able to explain that far better than I can. So let me turn it over to them and ask, why did you do this? What was the motivation for writing this book, and why did you think it was necessary, either sort of in general or right now in particular?
I'm happy to take first crack at that one, but let me also just start by thanking everybody for being here. Thank you to the Office of the Dean for co-sponsoring this event, and thanks especially to the Goodson Law Library, not only for co-sponsoring this, but for helping bring the book to fruition. Maggie mentioned the Wild West part of our research, and I should single out Jennifer here, who actually tracked down the handwritten ordinances of Dodge City, Kansas, which forbid people from carrying guns into the city in the 19th century. So very, very grateful. Thank you so much to everybody at the library. So to return to the question of why this book, maybe especially given that Darrell and I have been writing on this area since, I mean, even before Heller was decided, but certainly for the last 10 years, sort of spanning the life of what we might think of as the sort of modern Second Amendment. We've engaged with it both in solo authored work and together, law review articles, op-eds, debates, briefs, and I think what we found was there were just certain kinds of arguments that we couldn't make within the confines of any of those genres, and so when we were asked by Alex Tessis, who's the editor of this Cambridge series, to contribute a book on the Second Amendment, we jumped at it, and the goal was, as Maggie suggested, to sketch out what it would really mean to address the Second Amendment as a matter of law, which again, maybe doesn't sound very radical unless you spend much time in the debate, in which case it's answering or attempting to answer pretty big questions. You know, we're 10 years now into this lifespan of what's effectively a new constitutional right, and there are obviously massive disagreements about particular cases, whether particular regulations do or do not conform to that right. But there are a deeper set of disagreements that we're really trying to get at here about what counts as a legitimate Second Amendment argument. Like, what is the grammar of, you know, the discussion? And the goal of the book is less to give particular answers to particular questions like, is an assault weapons ban constitutional, and more to say, like, here's how to go about that discussion if you're going to be using the language of the law. So I think that's what inspired it, and that's what we're sort of hoping to achieve with it.
I totally agree with that. I think the only thing I would add, sort of, you know, on a personal level, and it's you know, it's a little bit of navel gazing, but I'm an academic, and so I get to engage in that kind of stuff, is that our sense is this is the first time that you know, in our lifetime, you see sort of an individual right sort of emerging in real time. There's not too many other areas I can think of off the top of my head in which you're basically starting from scratch. It's a sort of tabula rasa, at least on the federal level, in some sense. And as an academic, it's incredibly exciting to be able to sort of get in there, roll up your sleeves, start working, thinking through these ideas, where there's not a whole lot of other stuff to work through or against, and sort of being having an opportunity to essentially be at the vanguard of opening up an entire area of constitutional research, sort of being able to inaugurate a field is incredibly exciting for legal academics, and that's, I think, another part of the motivation of doing this project, which is sort of more self-regarding than sort of other-regarding.
So other than the newness, are there things about the Second Amendment that distinguish it from other constitutional rights? So you both write about other areas as well. Is the Second Amendment weird in any ways?
Yeah, I'll answer that or take a crack at that, at least in terms of how is it different as a scholar to engage with. Doctrinally, there's all kinds of differences, which we'd be happy to discuss at length, but just as a scholarly matter, there are things I think that are different, or at least are exaggerated in this field more than in some others that I work in. One is that the scholarly debate, a bit like the gun debate writ large, tends to push people to the extremes, and people get sort of coded in sort of a binary fashion as for or against the right in a way that is, I think, less true in some other areas of constitutional law. Like when I'm on a panel about federalism or the First Amendment or something like that, I'm not usually asked, are you for or against it? Like, it's not like do you believe in the First Amendment? It's not like a coherent question. Like, it doesn't actually track. There's differences of opinion, like do you think Citizens United was rightly decided, whatever. But I'm regularly asked, do you believe in the Second Amendment? Right? Which is just not the kind of thing that one is used to engaging. I think we hope that we're sort of turning the corner, and again, a goal of the book is to sort of turn the corner to the more, we think, interesting and tractable set of questions like, what are your beliefs about the Second Amendment? How does that map onto what kinds of gun regulations you think are constitutional? But that binary part of it, I think, is different. I think it's also true that there's a little more, again, as compared to other areas that at least I write in, you know, I get calls about, from people who have very strong views on guns, and I don't get that. When I write a First Amendment article, I don't get an angry phone call with a lot of name calling and profanity. I get that when I write on guns. Like they hit there's a 3-minute limit, I guess, for our voicemails here, and they regularly hit that and then just get kind of cut off. That's different, and not something you know, if I write something about, you know, Wittgenstein and free speech theory, nobody gets exercised about that in quite the same way. Could go on, but that's two, at least, that sort of stand out to me.
So do you think it's possible to make a dent in that by writing about doctrine? Are you know, I mean, is it a fair critique to say that you're sort of going too deep into the woods by focusing on all this doctrine and just sort of taking it as a given instead of, you know, manning the parts and trying to get rid of all of it?
Well, I mean, you know, we kind of think it's worth the effort. That, you know, I think I speak for both of us when we say, you know, we came to law school, we became lawyers, we think that law has meaning, that law is important, that law is distinctive in some way from other types of arguments or fields or areas of human endeavor. And we also have, I think, a strong feeling that law really has an important sort of disciplining function, that if you're going to traffic in constitutional arguments and you're going to traffic in legal arguments, then you have to sort of respect the terms of how you make those arguments. And notwithstanding the fact that somebody can just sort of, you know, dismiss the priors and say, I'm not talking about law, I'm talking about God-given rights, I'm talking about natural rights, I'm talking about something else. Our point is, well, at least by clarifying, you know, the terms of the debate and saying, all right, are you engaging in a legal argument? This is how we engage in legal argument. That is worthwhile in of itself.
Yeah, and I think, I mean, in addition, there is sort of a sense of like sufficient unto the day or the problems thereof, that there's a lot happening in courts right now with regard to the Second Amendment. In fact, another thing that's maybe, you know, maybe not unique, but incredibly, you know, notable in Second Amendment land is that there are fundamental open questions that courts are confronting that I think are even more, and this is going back to the tabula rasa point, that are sort of even more, you know, open field than we encounter, at least in other areas where we write. And so we have found that, you know, courts, scholars, litigants are eager to learn something. Like they're approaching open questions like, you know, are, you know, undocumented immigrants entitled to rights under the Second Amendment? Are they the people that the Second Amendment comprehends? What about these 3D printed guns? Are those arms covered by the Second Amendment? Right? You don't get that answer by staring at the 27 words of the amendment or by reading Heller, which gives remarkably little guidance as to those kinds of practical questions. So to the degree that we're court-focused, I actually think, you know, it's a fair point, that a lot of this is trying to explicate what happens in courts and trying to maybe, you know, reflect back to courts what they're doing. But that's, you know, that's sort of worth the candle, I think, you know, for us. If we make a dent on that, I think that'll be, that will feel, you know, very, very successful on that.
Do you find that courts are all going in wildly different directions, or are they kind of playing from the same playbook?
It's a good question. I think that for the most part, and maybe this is actually also an answer to why we write this book now as opposed to earlier, we couldn't have written this book in 2008 or 2009 because then courts really were pointing in all kinds of different directions. Right after Heller, unclear really what the basic sort of mechanisms of doctrine would have been. After 10 years and more than 1,000, as there have been, more than 1,000 post-Heller Second Amendment challenges, the dust has started to settle a fair bit. And to overgeneralize a little bit, the federal courts of appeals, anyway, have now, as of the First Circuit's decision, unanimously endorsed what they call the two-part test. The first part of which is a threshold question: is the Second Amendment implicated at all? Because some gun-related activity just does not register as Second Amendment activity, like concealed carrying, carrying by felons, by people adjudicated mentally ill. They just don't even get to invoke the Second Amendment in the same way that libel and child pornography are just kind of carved out of First Amendment coverage. So that's sort of step one. And then step two is, well, depending on the burden that's placed on the rights holder and the government interests involved and how close the regulation comes to the core interest of self-defense, you apply some kinds of means and scrutiny. That's a broad description, but they basically kind of circle together around that, and you see them using essentially the same sort of machinery. That said, there are big, I mean, maybe you could,
Yeah,
the
sure.
text, history, and tradition is a big alternative.
Right. So there are outliers or dissenters of the two-part test. The most prominent one is an opinion in what's known as Heller 2 by then Judge, now Justice Kavanaugh, who said the two-part test is, at least the second part, is not legitimate, that it involves some sort of balancing of rights versus interests, and that some sort of text, history, and tradition and working through analogy is the way that you do Second Amendment adjudication, which would make it different than most other individual rights. I've written on the closest analog within the Bill of Rights would be the Seventh Amendment in terms of that kind of approach. But I think, taking a piece of what Joseph said, I think we're in agreement that in some senses, the two-part test is accomplishing what any kind of constitutional mechanism, adjudicative mechanism, has to do. It's got to figure out what is the territory of actual constitutional interest. Not everything, not every question that comes up is in the constitutional domain. And so, bank robbers who pull a gun and say, "Give me your money," yeah, they're speaking and they have a gun, but that doesn't mean that these are constitutional questions. So some things are just off the table. And then once you find that something's on the table, the typical way of approaching a problem is not everything is protected up to the maximum. There's all kinds of ways of tailoring. And my research when I did the piece on the Seventh Amendment just sort of proved that even if you put something like a text, history, and tradition label on something, these two kind of tasks have to be performed through some sort of mechanism, and the two-part test just happens to be one that I think the courts are familiar with. It's used in a lot of other areas, and they sort of adopted it sort of off the shelf as just the workaday tools that all judges use.
So that gets me back to the weirdness question. You have a chapter on what you call the grammar of the Second Amendment, and I'm curious whether the grammar you find courts using or that you think they should be using is the same here as it is in other areas. But what it sounds from what you've said is that courts got this new animal and they weren't sure what to do with it. And so, kind of understandably, they drew tools that they were familiar with from other areas and saw how they would apply to this new thing. Is that roughly what has happened? Or in a different way of asking that is, like, what happened between 2008 and 2009 when everyone was all over the place, and then when they came together that made them come together in some way?
You want to say about the grammar?
Yeah, so I think it's true that the grammar is, the grammar comes from Philip Bobbitt, famously wrote it 30 years ago or more, these sort of different sort of tools, these modes of constitutional argument. I think what might be different about our book and about the Second Amendment is, he's writing his book about constitutional law, in general, not on a specific issue. And it's interesting to see, like, which kinds of these, he calls them modalities, which terms of art, which terms of grammar get accentuated. How do they work with each other? So one of the things, for example, that's happening right now in Second Amendment litigation is, what do you do when you have a text, history, or tradition analysis, but it's running up against some sort of precedential aspect from Heller itself? Which one of these things in a hierarchical system of adjudication is supposed to take precedence? And so that's something that in the sense that, yes, the tools are the same, but it's really interesting to sort of think about and read and watch how these different modalities get used in actual cases, especially after, in some senses, the sort of creation of different sort of categories of constitutional methodology, which drive persons with certain methodological commitments to some types of tools or some types of grammars as opposed to others.
Yeah, I mean, and just to amplify that maybe and give an example or two, for anybody not familiar, like Bobbitt's basic argument, there are 6 modalities of constitutional argument. This is the language in which we speak when we speak about the Constitution. Arguments not employing these languages are not constitutional arguments. It's not a valid constitutional argument to say, I like guns or I dislike guns, therefore this gun regulation is unconstitutional or constitutional. It is valid to say, arguing from tradition, we have traditionally kept guns out of the hands of dangerous people, therefore it's constitutional to keep them out of the hands of, let's say, people who've been convicted of a felony now. Like, that's the sort of mode. And that's what we're trying to do in the book, is less point to outcomes and more point to the grammar. That's what we call the language of the argument, and sort of, put those sort of tools out there. To answer the question about what's different here, or potentially tricky, I mean, one is that, as opposed to Bobbitt, who says there's no hierarchy among these 6. These are just the different modalities one can use. There's no one that predominates over the other. Descriptively speaking, at least in Second Amendment cases, what we're seeing is at least some get more prominence here than they do in other areas. History is, I think, as Darrell was suggesting, is the big one. I think partly that is because largely it's because Heller is self-styled as an originalist opinion, and many people have read it as sort of requiring, and this is how now Justice Kavanaugh reads it, as requiring an approach which is solely based on text, history, and tradition. That is not even strict scrutiny, but just solely by analogy to historical sources. That is a tricky thing to do when you're adjudicating a right which, for more than 2 centuries, was inert. Like, another modality is precedent. There is effectively no Second Amendment precedent, certainly from the Supreme Court, on this private purposes right until 2008. There's not a federal case that strikes down a gun law on Second Amendment grounds for more than 2 centuries. So the history, like the precedent, sort of came in much later in the game than the history, unlike in many other areas where, take the First Amendment as an example, some people say the First Amendment theory and doctrine started when Holmes wrote his dissent in Abrams in 1919. That's at least a century of precedent and history kind of growing up and informing one another, and it's harder to do that in Second Amendment cases. I mean, hundreds of Second Amendment cases since Heller have involved a challenge to the federal law which bans felons from possessing weapons, right? That's a law which, in its first form, was passed in the 1930s and then was broadened in the 1960s, right? Does that count as, a traditional or a historic law? It's less than a century old. Most courts have said yes, but according to what metric? Like, those are really hard questions, going back to that issue of the courts maybe have some general agreement about methodology, but there's some really fundamental hard questions about, what makes a law long-standing, for example.
So kind of moving back a step of generality, what's the basic theory of the Second Amendment that courts are using? Is it just self-defense, or is it more complicated than that?
Well, I mean, all the opinions sort of take Heller's statement that the Second Amendment the core reason why you have the Second Amendment is about self-defense. But I think all of them in either expressly or implicitly sort of understand that is not, it can't be an organizing theoretical principle for all of the Second Amendment. And let me give you some sort of concrete examples which we use in the book. I think we're all in some agreement here that if you are a felon, or if you're even an incarcerated person, you have not surrendered your right to self-defense. That is, if somebody is attacking you, you would have a right, some sort of moral rights, and certainly maybe even some legal rights to defend yourself from an attack. But almost nobody is sort of out there saying that when they start tossing beds in the cells and find homemade knives and stuff, that there's some sort of Second Amendment issue anywhere in that place, no matter how central self-defense is to the Second Amendment. And so, our point in the book is that Second Amendment adjudication or Second Amendment theory can't just stop at self-defense. Breyer famously says it's the beginning of an inquiry, not the end of one, in his dissent in Heller. And so we've tried to sort of expand on, well, what do we mean by that? If self-defense isn't going to be sufficient for an organizing principle, what could be? And sort of taking, taking a little piece from our familiarity with the First Amendment, and in conversations we sort of came down to sort of three theories that we could sort of unpack the self-defense idea. One would be something about not self-defense simpliciter, but something more like safety. So when somebody like Wayne LaPierre of the NRA says, the only thing that stops a bad guy with a gun is a good guy with a gun, he's kind of talking about what we think of, as a sort of a marketplace. We say it's like a marketplace of violence. So his idea is that good uses of guns will end up outweighing bad uses of guns, and everybody will be better off. And that it's really about safety, that what we're trying to achieve with the Second Amendment. The second one would be something like autonomy. This is that there's just something inherent. I can have a gun for any reason or no reason. I just have a right to do it. And in fact, there are some surveys in which people answer the reason why I have a gun or want a gun is because of the Second Amendment. It's just, that's it. No other reason. And it sort of plays out a little bit in areas where seem totally counterintuitive, like persons that really, it would be hard to imagine that they would actually have the ability to use the gun for any other purpose other than their own sense of autonomy. So there are cases in which blind people have sought, no, seriously, like blind people have sought rights to carry a pistol, or to hunt, or to do other kinds of things. So there's sort of this autonomy aspect. And the third one is the one that tends to percolate around in the historical sources when we're talking about discussions about standing armies and things at the time of ratification, and also populate a lot of the probably the high level, probably most inflammatory kinds of rhetoric, which is it's an anti-tyranny provision. It's what Kaczynski once called a doomsday provision, that you have guns to rescue the people from tyranny. And we see these as sort of the three sort of animating potential theories that at least go further than just self-defense simpliciter as a way of sort of organizing what the Second Amendment's all about.
And I'll just quickly tie those back to Heller and then and to maybe to the scholarship going forward. So one of the single paragraph of Heller that has been central to post-Heller Second Amendment litigation is what's sometimes called the exceptions paragraph, or a paragraph in which the court says, of course, nothing we say here is meant to cast doubt on longstanding prohibitions such as, and then it gives some examples, but they include, among other things, bans on possession by felons, as Darrell was just talking about, the mentally ill, bans on dangerous and unusual weapons, and bans on guns in sensitive places like government buildings, right? So those four exceptions, and there are others, but those four describe a lot of gun regulation, at least arguably describe a lot of the gun regulation that we have in the country right now. The trick is sort of making those jibe with any underlying theory of the Second Amendment that makes sense. So if, for example, and this is the sort of felon, incarcerated felon, or person who served his or her time, it's very hard to say, like, if the underlying purpose of the right is self-defense, why not have felons, or why do mentally ill people and felons get carved out of coverage? Or they may be people who have special needs for self-defense, right? It's not a right that they lose. Self-defense isn't a right they lose. So you say, okay, maybe then it's really about prevention of tyranny. Well, if it's about prevention of tyranny, what kind of guns are you going to need? Dangerous and unusual ones, right? And where are you going to need to take them?
Government buildings.
Government buildings, right? Yeah. So it's hard to make it map onto the theory in any kind of coherent way. And so that's the sort of tie into Heller and why we think this is tricky. And then the going forward, the sort of table setting that we hope maybe this chapter of the book in particular helps to achieve is that for a century now, and again, we could peg it to Holmes and Abrams, but there are others. 8 years later, Brandeis does the same thing in Whitney, Zechariah Chafee and other people writing in the First Amendment, started a century-long scholarly judicial conversation about what free speech is all about, and the answers to those questions point in different directions doctrinally. Like, if you think free speech is about a marketplace of ideas in which over time the truth will out, well, then that's one theory. But it's different than saying, in the sort of Meiklejohn sort of approach, that it's about democracy, in which the lodestar isn't truth, but political participation or democratic legitimation or something like that. If it's about autonomy, individual expression or self-realization, that points in yet another direction. It's hard to maybe justify harder to justify First Amendment protection of art under a truth theory or a democracy theory. It's much easier under an autonomy theory. Those all point in different directions in concrete ways, and we hope, that the Second Amendment can have a similarly engaged discussion going forward. If it's about personal safety, that points in one direction with regard to which arms and people are covered. If it's about prevention of tyranny, that points in another direction. If it's about just self-actualization and sort of autonomy full stop, that points in yet another direction. So this is mostly recap, but just that's what we're aiming to do, I guess, in that chapter.
So is no one doing that now? Are courts not trying to come up with a kind of general theory, and are academics not doing that either?
I think that courts tend to just cite the Heller self-defense, this is the central component, this, self-defense is the core, and miss this. Scholars, I think, are largely still, to the degree there's scholarly discussion happening about the theories of the Second Amendment, they're still mired in the pre-Heller debate about whether it's about organized militia or private purposes. And so again, this is going back to the question of, are you for or against the Second Amendment? Still, 10 years down the road, when we appear on panels or on debates, we get asked questions often about, well, what about the well-regulated militia? Isn't that what it's all about? And we have to say, look, as a matter of doctrine, at least, we're past that. And, but no, there's not a lot of theory about, after Heller, what is the private purposes right about, if not malicious?
And I think implicitly, even though, lower courts do acknowledge the sort of self-defense is the central component, the core of the right, they all sort of understand that they're, in some senses, that is not the driving force for the doctrinal analysis. Because if that was true, that would mean that any assertion of self-defense by any person would trigger some sort of strict scrutiny, and you would have to find, is there no other way that you can, that you can basically do this kind of thing without impacting the core of the right? And that's why so much of the first step in this sort of two-part test ends up getting elaborated. It's, it's self-defense except for felons who might actually really need guns, because that's already accepted out from the Heller decision already.
I think just one other point to emphasize is when courts invoke or court scholars, anybody, invoke sort of self-defense as if that's the same as the right to keep and bear arms, that's making an error as well, because this is a right essentially to have a means on hand should the need for self-defense ever arise, right? To carry around a gun is not to exercise self-defense, that's to be prepared in order to exercise it should the need come up. Self-defense doctrine, as those of you who've been through crim by now know, has all kinds of things built into it about proportionality, necessity, the sort of need. You don't just get to choose your own, your own perceived threats, right? And that's different than the right that's asserted with the Second Amendment, which doesn't have all that kind of stuff built in. There's a way in which if Second Amendment doctrine actually followed where self-defense doctrine is, it might actually be more limited than the right that's being asserted here. So even when people are just focusing on self-defense, I don't think yet, at least, there's really been a thinking through of what that would mean. Fortunately, most gun owners never have to use their guns in self-defense. It's a weird fit between that interest and the underlying right.
So what are the issues that are percolating through the courts now, and what do you see, like 10 years out or 20 years out as the big questions?
So I think in the short term, I think we feel pretty confident there'll be another cert grant probably within 3 years, would you say?
Yeah, that's it.
Yeah. So public carry is an important issue. Is there a right to carry a gun, and in what form outside the home? Because Heller's opinion itself was just limited to Richard Heller, who wanted to have a pistol in his house for self-defense in the home. Then there's the question about, okay, what kind of arms? The whole issue about can you put restrictions on magazine capacities? Can you put restrictions on the types of guns that somebody would be able to carry, long guns, assault rifles, that kind of thing? That's sort of the short term. I think those are the two big short-term issues, and likely to be resolved within the next 5 years or so. Longer term, I think there's all kinds of really interesting issues. We think are interesting about you know, the Second Amendment and how it ends up getting adopted to new kinds of technologies. So what happens if you end up making smart guns and the guns don't fire unless the actual owner? What does that mean for the Second Amendment? What about things that aren't really arms in the sense of like a pistol or some sort of firearm, but tools, technological tools that one would use for some sort of self-defense means, whether we're talking about software or malware or whatever kinds of things that we might think of. Those fall within the sort of Second Amendment right to keep and bear arms, register or not. And then I think the other thing that is going to be important going forward, and we're seeing it all the time, is how Second Amendment doctrine and Second Amendment rights start to impact other types of rights, whether we're talking about sort of the right to exclude people off your property. Some states have sort of forced entry laws that say that if you're an employer, you have to allow somebody onto your property, or at least into the parking lot with a pistol, and can't ask them whether they have it there. There's those kinds of laws that the Second Amendment themselves doesn't require, but these are sort of pro-gun laws of various kinds. Issues about taking your guns to a public protest, is that both a First Amendment and a Second Amendment issue? And then there's all the sort of, you know, issues about the sort of intersection of other areas of scholarly study with this area. What do we think about sort of race and guns? You know, who can actually be seen as a legitimate sort of protector, private citizen protector of the community? How does the issue of sort of the private use of violence, the empowerment of the private use of violence through a right to keep and bear arms interact with things like race, disparate impact, gender? I think those are all the really interesting issues down the road.
I agree.
So how does someone get better answers to those questions from reading your book? So, I mean, one I
Wow.
think
Got all the answers right in the back.
I mean, one I think obvious answer is more scholars should be writing about this, and it's baffling why. I mean, this is all fascinating, and it's weird that more people haven't been tackling this in a scholarly way. But so I thought about those questions yesterday, and then I read your book. How have my answers improved?
Well, I think our hope is that in some sense we're like giving a framework and a kind of architecture for sort of fitting in what you might think is an important issue with, you know, with what we've said in the book. So you don't have to buy our sort of three theories of, you know, of what the Second Amendment is for, but kind of like, you know, where the First Amendment was, again, we keep going back, First Amendment was in, you know, in the middle of the 20th century, you know, once people start writing about them, then you have something to push back. You know, the Miller-Blocher thesis of, you know, safety or the marketplace of violence is wrong for these reasons, and here's how something they haven't thought about impacts that. But, you know, I think it's useful if we are developing a kind of field, developing a kind of vocabulary for theorizing about the right, in which other people that may not really think of themselves as really interested in Second Amendment stuff will end up saying, actually, this is really relevant to the things that I'm thinking about or writing about, and I never really thought that, you know, I thought it was about, you know, these sort of fringy people that write, you know, on guns, but actually it's really relevant to the stuff that I'm thinking about too.
Yeah, I think that's right. And I mean, you know, to pick, like, if you're going to pick an example, like an assault weapons ban, for example, as Darrell mentioned, this is a very prominent area of Second Amendment litigation, these sort of class of arms claims, they're called, bans on high-capacity magazines or assault weapons. If you're confronted with one of those, your first instinct might be to look for the cases, like, you know, what's the sort of precedent say? And of course, we discussed, like, where the kind of precedent is, but you'll find, as many courts and, you know, litigants and scholars already find, you're just going to run out pretty quickly. There's not a definitive statement, yes, these are, yes, these aren't. Many courts assume, yeah, okay, they're arms, but, you know, for the most part, they can be regulated because they're not, you know, so useful for self-defense reasons. Hopefully, in the process of reading the book, you kind of figure out, like, okay, here's my assumptions about why they should or shouldn't be covered. Like, I'm a person who believes self-defense is really important and that guns are really important to self-defense. Are these the kinds of guns that are really important for that reason? You Maybe that'll sort of help illustrate that. If you think instead the Second Amendment is about the prevention of tyranny and not really so much about self-defense, well, then maybe, the constitutional protection of an AR-15 registers as a much more important issue, where handguns are sort of the quintessential self-defense weapon, AR-15s are the quintessential, tyranny defense weapon, maybe, something like that. Then at least we've clarified the terms of the debate. We know kind of where we're coming from with regard to your underlying theory of what the Second Amendment is all about. Hopefully we can show people what's hard about historical reasoning, right? Like, one of the things we talk about in the book, and which came up in the Heller litigation, both at the Court of Appeals and at the Supreme Court, is the difficulty of saying any kind of weapon today is a lineal descendant of any weapon that existed at the time of the founding. Like, that's a lot of analogical work that's being done in a statement like that, because guns don't have progeny. Like, they don't replicate it. To say that an AR-15 is the lineal descendant of a musket is to make all kinds of assumptions about functionality and functionality for what purposes. Hopefully we can put those questions forward, even if we don't have, we don't provide like a definitive answer to whether we think a particular law is constitutional.
So what about more kind of popular and political versions of these debates? How would you like to see those changing if everyone reads your book?
Well, I want to eliminate the you're against my right to self-defense, counter to somebody that says about any sort of gun regulation, because I think that's, again, that's a misnomer. These things are, they're related, but they're not the same thing. So, if anything, I would kind of hope that, somebody reading this book would say, oh, you're right. Self-defense is not coterminous with the Second Amendment or the right to keep and bear arms. These are two different things. And that might be the wedge into sort of thinking a little bit in a little more nuanced fashion about these other kinds of, other issues. I guess the other one would be that to the extent that, the book is read by persons other than sort of, academics, it will equip people that are, I think, kind of yearning for what is this right? What are we talking about when we're talking about these things? I'm hearing a lot of yelling, but I'm not getting a lot of content here, and that would help sort of, in some sense, refine and in some sense sort of help the political discourse, so that when you have somebody say to somebody else, you wouldn't ban the Bible, so why would you ban an AR-15? That somebody would be able to say, I hear what you're saying, but you're not talking in a legal register, you're not talking really about law, you're making a rhetorical argument. And it's a powerful one, but it's rhetorical. So let's talk about, well, why do you think that banning the Bible and banning an AR-15 are related? What makes them related? And that would help, I think, in some sense, maybe the political discourse.
I guess I'll just add one thing to that, which is that I think we hope to break down some of the binaries that we've been describing here, right? That, often hear people talk like, I oppose gun regulation because I support the Second Amendment, or vice versa. And if there's a theme from the book, it's that is just a false choice. That has historically not been the way we've treated things. That's not what Heller requires. The vast majority of Americans support what they understand the central holding in Heller to be. That is the individual right to keep and bear arms for private purposes. That's 3/4 of Americans supported that decision when it was handed down. Both political parties. This was handed down in the middle of a political campaign. Obama and McCain both put out statements supporting that part of the decision. And also, strong majorities of Americans support tightening up some gun regulations, including, for example, expanding the system of background checks. If you put the overlap there, that means there's got to be a pretty big part of the country which believes both in an individual right to keep and bear arms and certain kinds of reasonable regulations. And that's, I think, what we want to show is that the Constitution doesn't take that off the table. It doesn't force you to choose between one or the other. The example we start the book with is the last time there was a big push to expand the system of federal background checks. It's happening right now, but the last time there was a big push was in the wake of the Sandy Hook massacre. And you may remember the Manchin-Toomey Amendment, which was proposed, would have not made universal, but at least expanded the system of background checks, which requires people at certain purchases to check to make sure the buyer of a gun is not prohibited because he or she is a felon or adjudicated mentally ill or something like that. Wildly popular proposal. Polling at the time had it, and some of them, more than 90% of Americans supported this. 75% of gun owners, 74% of NRA members, right? Just unimaginable to find so much agreement on a particular kind of legislation, let alone one involving guns. Doesn't even get a vote in the Senate. NRA leadership opposes it vociferously. And we were like, it's fascinating. How does that not happen? How does a piece of legislation that popular not get through? Certainly an interest group story there, but you can actually look at the polling. What were the reasons of the 10% or so who opposed this? The biggest reason people gave was it would violate the right to keep and bear arms, right? And that is, in one way or another, a claim about constitutional law, and it's, we think, a misunderstanding of what if it's a claim about actual law, what the actual law requires. If we could do anything to sort of break that down and avoid it happening, let's say, next time, then we'd be very satisfied.
Mm-hmm.
So let me ask a different question, and then I'll stop and open it up to questions from our audience. What was it like to work together?
Great.
It was a lot of fun. Yeah.
Yeah, we work together. We write together really well. He writes a lot faster than I do, but I think we have a good sort of relationship in terms of I'll write something, he'll pull out the purple passages and sort of make it sound better. I'll read his and I'll say, I'm not sure that this is quite the metaphor that you want to use. Let's try these other things. So, both at the sort of, big sort of architectural level of sort of just, we have the sort of same style, sort of, let's plan what we're going to do, let's outline it, let's make sure that we have that down and tight and get feedback from our colleagues who were very generous in this project. And then in the actual writing, I think we have very compatible sort of writing styles. I'd never co-authored with anybody before, so
it's been a lot of fun. I mean, this is not the first time we've done it, like an article, so we sort of knew a little bit what to expect. But a book's a different project, and this was the first time we'd really, done something like that. I mean, I couldn't agree more. It was just, I mean, in as much as part of the point of the book is to try to inspire a scholarly discussion, it's nice that it was essentially the outgrowth of one. I mean, this is essentially us talking to each other and debating, and we agree on a lot of things, we disagree on some others, but it all kind of, washes through, hopefully, in the pages, and hopefully other people will disagree or agree with us going forward.
Jamie Boyle.
Fascinating, love the book. As you know, read many versions of the book. So you've written the grammar of the Second Amendment, I'm thinking of it, Strunk and Wesson, I guess is the subtitle. How's Justice Kavanaugh's grammar? What's your legal writing markup? Is he committing a neologism? Is this like split infinitives? No one cares about them anymore, except those of us who think it should be to go boldly and not to boldly go. Is this an innovative move? Is it just an archaic move that is being reintroduced into the language? What's his grammar like?
It's a very interesting question, and I want to reserve judgment until we see more, but we do have a pretty good data point on this because he wrote a solo authored dissent on the DC Circuit, presumably speaking only for himself and his own views. And again, to reiterate, his stated view in Heller 2, again in dissent, is that the Second Amendment must be interpreted solely with regard to text, history, and tradition. He chalks that up partly to what he thinks Heller requires. I think that's a misreading of Heller, so negative mark there. And most judges, I would say, are in disagreement with Kavanaugh on that as well. He also seems to think that that is a constraining move with regard to judicial discretion and power. And for some of the reasons that we mentioned earlier, I think that is also incorrect. I think to try to argue by analogy to 2 centuries ago without the sort of mediating influence of precedent connecting today and then is just a recipe for describing, as he does in that case, a law as a ban that other people would describe as a restriction, as the majority in that case describes as a restriction. There's a searching there for kind of rules over standards and sort of basic sort of doctrinal machinery, which is not all governed by appetites about the right to keep and bear arms. It has to do with appetites of sort of what you like to see in doctrine. We don't say a whole lot here about rules versus standards and that kind of thing, but I'll say that in an area like this one where there is relatively little precedent, I think we may see more doctrinal innovation than in other areas. This actually came up at the oral argument as well. I'm gesturing in the direction of Walter Dellinger, who argued the case. Came up at the oral argument as well when Chief Justice Roberts said something like, well, I don't know why we would endorse the tiers of scrutiny or anything else. That's just sort of baggage that the First Amendment picked up, right? It's nothing in the Constitution that says we have to do that. We could go with something totally new. And Kavanaugh seems to be sort of doing that. That doesn't strike me as, I don't know, judicial self-restraint in the same way that maybe adopting well-tested standards another way. How he's going to resolve a particular case when it comes from, I would sort of keep my mind open to it. But
yeah, the only thing I would add to that is I think Kavanaugh's approach is there's a couple things. One is it would make the Second Amendment adjudication in some sense special, right? Most other rights are adjudicated through a kind of we figure out what's covered, and then we use some sort of tiers of scrutiny, however it's sort of denominated. Sort of going that route would actually make the Second Amendment in some senses outlier and make it more like the Seventh Amendment, and even then the Seventh Amendment, has things at the edges. The reality is, if Kavanaugh would prevail with a sort of strict text history and tradition analysis, I think I feel fairly strongly that it would have to operate on both sides of the equation. That is, if you're going to start talking about lineal descendants of, muskets, then you're going to have to start doing the same type of enterprise with regard to restrictions, because federal prohibitions on firearms on airplanes didn't exist until the 1960s. And so, if you're going to start talking about sort of lineal descendants, analogs with, the muskets of the 18th century, then you start having to talk about, well, there were prohibitions on carrying, putting guns on stagecoaches or traveling armed with other persons. And, this is the sort of analogy that we're going to play, and at some point you have to sort of figure out what your, as Fred Schauer says, what's your, rule of relevance? What makes one analog relevant to another? And it would be a completely different type of reasoning in some sense, but it could very well be the kind that we get. We just don't know how many votes there would be for that thoroughgoing sort of history approach to the Second Amendment on the court.
Yeah, just one tiny little thing just to emphasize that the disagreement here, or the problem I see with the approach is it's not results oriented. It's not a question of which one is going to allow or disallow more gun regulation. In fact, Kavanaugh says, I think rightly in his Heller 2 dissent, that a history-based approach, depending on how you apply it, and this is the depending part that's really big, might actually uphold a lot more gun regulation than, for example, the application of strict scrutiny. And again, this is something we try to get clear in the book. There's a long tradition and history of gun regulation in the United States. Depending on how you do your analogies, that could open the door to a lot of gun regulations. It's not about his view is too broad or too narrow. It's really just that the methodology, I think, has some built-in problems.
Great.
So you talk a lot about historical analogies and tradition. Is there any room at all in the doctrine, either the way it is or the way you'd like it to be, for work by empiricists studying what is promoting safety in certain contexts or not, or how guns are actually used in particular settings? I can imagine all sorts of works, minor things that might make a big difference in suicide rates. Is any of that relevant, or do the gun rights kind of pro-Heller crowd think once you go down that road, it's a pure regulatory issue and you've kind of given up the right?
So answering sort of in reverse order, yes. On the last part, there are definitely voices, and Kavanaughs is one, he's not the only one, who say that if you start going down that road, then you're doing interest balancing, and Heller says you can't do that. In practice, though, especially going back to the second step of that two-part test we mentioned earlier, courts absolutely are receptive to empirical evidence, social science evidence on the kinds of disputed questions that Darrell's describing earlier. I'll just take public carry as one. So as Darrell said, one of the biggest sort of battlegrounds in Second Amendment litigation right now is the constitutionality of what are usually called good cause restrictions. In other words, if you want to carry a gun in public, you have to get a license. In order to get a license, you have to show good cause. There is a lot of empirical studies been done on whether allowing more, easier access to guns in that way, more public carrying, reduces crime or doesn't. There's studies on either side. John Donahue at Stanford's done some of the, I think, really best. And this is going back to maybe Maggie's first point about Duke's strengths in this area. We're exceptionally lucky to be at a university which, outside this law school, has some of the leading people doing work on this. Phil Cook across the street, Kristen Goss across the street, Jeff Swanson down in psychiatry have done amazing work on not just public carry, but you mentioned sort of in passing the question of suicides. Fantastically important question and doesn't get as much attention in the gun debate as it should. So I'll just emphasize the majority of American gun deaths are suicide deaths, not homicides. And they are concentrated disproportionately among older white men in rural areas. They're not the kinds of gun violence victims people tend to see on the news or think about. But anything that can be done to reach that problem, I think, is relevant to the constitutionality of at least if you're doing a kind of means-end scrutiny.
And I think it kind of depends on where the entry point for that kind of data is. My thinking is, right now that data tends to sort of come in at the sort of tailoring stage. There's not a necessary reason that it can't be sort of invited in by reference to whatever historical regulations existed, right? There's tons of regulations about guns in cities. This is as Joseph has written, right? There's this division between the urban and the rural is long-standing. Well, it's not just arbitrary. We didn't just say cities are great. It's because cities are crowded. There's things that go on in cities where there's more danger present. And so that, in some senses, becomes a kind of entry point for, all right, what we're really worried about is the use of guns in crowded places that harms people. So if that's what if that's sort of part of what the Second Amendment architecture or ground looks like, then we can bring in this sort of, criminological data or whatever that would say, this is why it's dangerous. Yes, it is, in fact, dangerous. It's not just dangerous in, the 13th century. It's dangerous now.
Neil?
So just a point of information, Justice Kavanaugh generally describes his approach to constitutional interpretation as consisting of text, originalism, and tradition. He said it at his confirmation hearings. He says it in separation of powers cases, right? He says it certainly in substantive due process cases. And the reason why, and I'm not sure if you disagree, Joseph, I thought you said it's not really about whether it's outcome driven, there were just problems with the method. The reason why it ends up being outcome driven is that the argument from tradition is deeply rooted tradition, Glucksberg. It's as if the 20th century never happened, right? The analysis stops at the end of the 19th century. What happens in the 20th century? For the first time in 1910 or 1920, a majority of Americans are living in urban areas, right? There develops densely populated urban high crime areas in which the weapon of choice for criminals is handguns. We develop weapons that are easily in circulation in the possession of people that can kill many people in a very short amount of time, right? So if your tradition is Glucksberg, 18th, 19th century, it's going to decide a lot of cases. If your tradition is Obergefell, dynamic, evolving tradition, in which we look at gun control over the course of the 20th century in response to problems that 19th century Americans, let alone the founders, never could have imagined, right? Then you have a very different analysis. So one way of putting this in the form of a question for you folks, what is the grammar of the Second Amendment? What are the modalities of interpretation that are most conducive to taking into account not just what happened long ago, but the problems that are in existence today that the kind of folks that a Kavanaugh is going to be concerned with couldn't even have imagined, let alone had views with respect to?
It's a great question. I mean, and I should say the modality we emphasize, which is not one of Bobbitt's, is that of analogy. That's the modality which we think is actually doing a lot of the work, I think for the reasons that you're giving. When I say that the debate doesn't have to be one of scope, I mean that if someone looks at the same history, they might draw totally different conclusions about whether we did have, for example, an analogous gun regulation at the founding, even if it is Glucksberg level, you have to go that far back. You can look at what the gun regulations on the books in places like Philadelphia, New York, and Boston, not that many cities of that size, but those are the three big ones. And they had gun regulations in the late 1700s that would make the Brady Center blush. I mean, you couldn't have a loaded gun in some of these cities. It was incredible. And we mentioned the Wild West example earlier. The Dodge City Ordinance that Jennifer helped us track down literally prevented people from bringing guns into the city. Again, back in the 19th century. We're looking pretty far back. How far Heller requires us to look back is the question which I don't think, that Kavanaugh answers in Heller 2 or that Heller answers for itself, right? It says long-standing, but if we're going to look at bans on possession by felons, for example, as I mentioned earlier, the first federal law is 1930s. It's expanded in the 1960s. Most courts have been satisfied. Yeah, that's good enough. That's more in the, maybe in between sort of Glucksberg and Obergefell in terms of what timeline is needed, but maybe that's because they're just really scared of what would happen if we struck down, the federal law banning felons from possessing firearms. My point is just that if you say it's history, as text history and tradition in this area or any other, you're often just pushing the question. This is where I think we agree. You're just pushing the question to okay, how much history, whose history, when, what does it mean? And there's a lot of discretion that's going to come in at that stage. We may give, hopefully, some guidance on at least what's hard about that, even if we don't totally resolve it.
I think we have time for one more question.
When you guys are talking about the underlying theories that people use sort of to talk about the Second Amendment, is there any aspect of sort of national identity as being important to Americans uniquely in some sense of defending strongly the Second Amendment as they see it?
So I think that, we sort of tuck that within the idea of autonomy, that there's some sort of identity production about guns, about who can have guns. I mean, it plays out very much in the regulatory environment of prohibitions on guns for freedmen, for slaves, prohibitions on selling guns to Native Americans, for example, even back to things like the Declaration of Right, which specifically carves out Protestants as having rights. At the same time that Protestants are sort of said, you have rights to bear arms, William and Mary come in and have an act for the disarmament of papists, as they called them, right? Basically making Catholics take special types of oaths to get guns. So we sort of think about this sort of identity production and in some sense that kind of equality aspect of it as sort of baked into what we would think of as sort of autonomy interests.
That's right. That's a great question.
Thanks, everyone. Please join me in thanking.